juries in the jury room regarding the two messages I received from one of the jurors. I don't know how you want me to proceed. The second message, we just took a break right away. She just said she needed a moment. So I don't know what you want me to do.
Okay. We have a list of proposals in order.
You talk to the state about anything?
No, not yet.
No, I know the state's okay with the first one, which is allow this for the court to reconsider its position with respect to this witness testifying with a mask. The state had indicated to me yesterday that they would agree to him testifying without a mask. And as a matter of fact, I think the witness said that he anticipated that's what he would have to do. And the only proviso would be that the courtroom would have to be cleared and the phones of all people present during the testimony would have to be confiscated. We would suggest that that would be remedy number one that should be employed.
So I think the problem with that logic is it's assuming that it's the witness's mask that is making her uncomfortable, not the testimony about gangs. Because if she is uncomfortable and upset because she was robbed by a gang member when she was young, and that's the concern, we need to know that. So I think that's the first problem that we have, because we have to get the actual reason as to why she's concerned.
Well, within context, the first note indicated that was a question. Why does he get to see us and we don't get to see him? So I think that lets us know that it's the mask that's of concern and that the presumption of being robbed was being robbed with a mask. If it's gangs, we did a thorough voir dire during which the issue of gangs was addressed, and she's passed that hurdle, so it's not a gang issue, it's a mask issue. So that would be our first proposal. And if the court's willing to do that, I guess we don't need to get to a second proposal.
My concern is the second message that the juror sent over, where she asked for a moment. But so the record's clear. It says, "I need a moment. I can't listen properly. When I was a child, I've seen someone get robbed, and I am having an anxiety attack." So my question is, if she's able to proceed with it, or if this is going to somehow color her thinking. That's what I'm mostly concerned with respect to counsel.
Sure.
And that's a sword that can cut either way.
Oh, I understand. But
that's what I'm more concerned, and I'm also concerned about trying to interfere somehow with the jury's process. And if she just needs a moment, maybe we just send them to lunch now and not worry about it. But I'd still like to find out as to if she's going to be able to follow law and whatever happened. I mean, I don't know if she's already on the jury. She's already been accepted. You answer all your questions. I think we've crossed that bridge already.
Yeah.
So I don't know. I'm concerned, and I don't know how to.
And I understand and appreciate the court's concern, but the question is, what is precipitating her anxiety? And it's the mask. And yes, we can clarify that with her. I have no problem doing that. But it can't be gangs, because we discussed that at length during voir dire, and she cleared that hurdle and was put on the jury. Yes. But that would be our first proposition. If the court would consider that, that would be great. The second proposition would be, the first of her two notes was a question. And it was, why can he see me and we can't see him? Which goes to the heart of the confrontation clause. And also lets us know that her concern is the mask. And the jury instruction that was proposed by the state and accepted by the court doesn't address the question at all. It says, consider him like everybody else. Well, how are they going to do that? They're going to be instructed the way that they consider him as judging facial expressions, which they can now not do. We made we proposed a jury instruction, which the court rejected. And we would ask that the court at least consider whether or not it would offer some variation of that, such that the answer to the juror's question can be met, which is why. That's why. And I think they need to know that the why does not concern any issue with respect to this particular defendant. The third is the problem that we had before, which is, as brought out during Mr. Alistein's questioning earlier. The state could have chosen any expert in gangs. They elected to choose one who has threats against his life that don't concern this case and is undercover. And therefore that they have precipitated this problem. I think Mr. Demons, Mr. Melly, I think our client has a right to a jury of his peers, one which has been selected and is seated, and his right to both confrontation and to a juror that has been seated supersedes all of the rights of the media, of the state to have an expert or a witness who could have been, and when they could have chosen any other expert. But our third proposition would be that we take the break and address this after lunch, after the jurors had an hour or so, and we then bring her in and see what her problem is. If it's not the mask, I'd be highly surprised, but maybe that's the first step. But we'd ask the court first to reconsider, and second, to reconsider letting him testify in this fashion, and second, to reconsider reading an instruction that gives the jury a little bit more than he's testifying in a mask. Let's continue.
If you have an instruction that's agreed to, I don't really have an issue with it. My issue was the way you drafted and crafted this instruction is that I'm telling the jury that I'm looking at the media's right to be here over his right to confront his accuser, and that's not the way the way it was crafted and worded to me was not the right way to handle it, and I wasn't going to do it.
Okay.
All right. So the second issue that you had is having the witness, and it was a testify without a mask. I don't have any issue with discussing that further with the witness. I did this because he told me he was in fear for his safety and his family's safety, and this is what he does for a living. And I made my decision based upon that because this is being live streamed. I don't know whether or not he would how he feels about it, and I guess that's subject to further discussion. As far as taking a break, I think that's the best way to handle it. We'll take a break, give the juror an opportunity to go have lunch, and when she comes back, the first order of business that we can do is to talk to that juror about how she feels and whether she's able to continue. If everybody's okay with that, that's the way we do it. We proceed, just see how she feels. If she's not suffering from anxiety anymore, if it's strictly an issue of the mask, then we'll know where that stands and we'll address.
That's why I put it at the end, so it could be easily excised. We do propose that as the proper instruction, but we'd like maybe to copy the rest of what we have proposed so that the court can look at it over the break and the state can look at it over the break. I've excised that last portion, and maybe we'd be better informed to discuss it upon return.
That's fine. What about the juror? I want to bring the juror in. I want to talk to her just to find out as to whether or not she's okay to proceed, and just find out a little bit about that. All right, so we're going to do that now. Can I have those two messages? This week?
Your Honor, while we bring her out, can I just say this? Yesterday I presented, and for some reason the internet access is not loading up. It will shortly, I'm sure. I presented the court with evidence that phone was being used while Mr. Demons was in custody. So the court said there's no evidence that it was being used by others. That's evidence. The fact that it has Stack Chaser Howard.
How are you?
Well, I understand, Judge, but you said you didn't. I'm just letting you know that I did present you with that exact information that you say does not
Bring the
exist.
jury. Ms. Leacock, the reason I brought you in is I had two messages during the last witness's testimony. And the first one said, I don't feel comfortable. Why does he get to see us, but we can't see him? That's your message to me?
Yes.
And the second was, I need a moment. I can't listen properly. When I was a child, I seen someone get robbed and am having an anxiety attack.
Yes.
And I guess my concern is, are you able to sit as a juror, or you think this is too much for you? I'm trying to figure out, and that's why we took a little extended lunch break to figure out whether you feel comfortable and you're up to it.
Yes, I feel comfortable, but I just don't think it was appropriate for someone to be masked up like that. And plus, you guys didn't even tell us. Like, you don't know what people have been through, so it just it shocked me, it shocked. So, yeah. But I do feel like I can do it. But that just wasn't appropriate.
I'm sorry?
I said I don't believe that was appropriate.
Well, some things I make certain decisions about things, and then we go forward with it, and I instruct jurors. And are you think you'd be able to follow those instructions, and you pay attention to the evidence, or do you think that you're concerned about the masking that is going to affect your ability to follow the instructions and follow the evidence?
Yes, I can listen and follow the evidence now that I know he's going to have on a mask. I can listen.
And the anxiety issue, we're past that, you're okay?
Yeah, I took my medication.
Thank you. The jury reflect the juror stepped out. Counsel remained along with the defendant. Counsel, she indicated she's still curious as to why the witness is wearing a mask, but she said she's able to follow the instructions, she's able to listen to the evidence, and she feels comfortable going forward. Anything you want to?
Yes, sir. We believe we again move for the court to employ the procedure of clearing the courtroom and allowing this witness to testify in a manner that will allow the jury to assess his credibility as it would any other witness. We also believe that in lieu of that the instruction that we offered, which answers her curiosity, should be given. The court indicated that it declined to give the defense instruction because of the component of the proposed instruction that referenced the court balancing and prioritizing the media's right to be here over the defendant's right to confrontation. We do think that is an appropriate part of the instruction, but short of that, the rest of the instruction, which excises that portion, we believe to be called for, especially in light of this witness's persistent curiosity. We answer all their other questions, and this is a pertinent one, because this is one that goes to the heart of why she is being denied the opportunity to make the observations pertinent to his credibility.
Thank you. What's this state?
Judge, I think we can come up to an agreement. I think we just need to more closely track the instruction. And going off memory that it's 3.9, so I'm pulling that up now as to exactly what witnesses are supposed to be judged on. And I think the problem is the way defense has it is you observe their demeanor and facial expressions, when the actual text of the jury instruction doesn't say that. The actual text of the jury instruction reads as follows. You should consider how the witnesses acted as well as what they said. There's nothing about demeanor or facial expressions in any way, shape, or form in that jury instruction. So I think if it read that the court has ruled the next witness will be permitted to testify with his face concealed with the exception of his eyes, the court has made this ruling because this witness has expressed that there have been threats made against his life by people unrelated to this case. Your jury instructions advise you to, and then to edit it to comply with the standard, to consider how the witnesses acted as well as what they said.
One moment to confer, Your Honor.
So Ms. Smith had a good point that it would not be appropriate for Your Honor to explain the logic behind your ruling or to say that it's because of this, but if you wanted to instruct them that the witness has said that there have been threats made against his life by people unrelated to this case, that would be fine.
Thank you. So my thought is, as far as the instruction was prepared by defense counsel, the first page reads, the court has ruled that the next witness, I'm just going to say Mr. Detective Polo, Danny Polo, will be permitted to testify with his face concealed with the exception of his eyes. The court has made this ruling because this witness has expressed that there have been threats made against his life by people unrelated to this case. We're going to leave it there, and I'll tell them that further instruction on how you judge credibility of witnesses will be given at a later time. All right? So let's bring the jury in. Let's get the witness back up.
The witness is in the BSO office down the hall, so I'm going to go to you grab him so they aren't anywhere. Can you approach to grab the statement, Charlie?
Without having a hearing, having them come bring their lawyers down here and everything else, it's a whole, it's a major move.
Understood, Your Honor. We believe the stakes of this matter are as high as they get.
Jury entering.